them. I decided to apply the principle of ordering here, that was order of graduation from the law school. So, even though it's not quite going to be the order in which they're presenting. And so I will start with Nicholas Katzenbach, who attended Princeton and then got his law degree from Yale in 1947 with a Rhodes at Oxford thereafter. He practiced in New Jersey and New York, and then taught law, first at Yale Law School and then at the University of Chicago. He then served as Deputy U.S. Attorney General under President Kennedy, as well as U.S. Attorney General, and then Under Secretary of State under President Johnson. During both administrations, Katzenbach played a leading role in the Justice Department's fight for civil rights. He was involved in desegregating the University of Mississippi, of Alabama. He worked with Congress to ensure the passage of the '64 Civil Rights Act. During his years as Attorney General, he repeatedly intervened on behalf of civil rights protesters and drafted the Voting Rights Bill proposed by the Johnson administration, and then worked to enforce the bill and defend it before the court. Thereafter, he served as General Counsel to IBM and recently been elected Chairman of the Board at MCI. Judge Pollack is a graduate of Harvard College and the Yale Law School in 1948. So we'll go out your term here. He practiced at Paul Weiss, then at the State Department, and then was assistant counsel for the Amalgamated Clothing Workers. In 1955, he was appointed to the Yale faculty, where he remained until 1974, and he was dean here from 1965 to 1970. He then, in 74 to 78, was at the University of Pennsylvania Law School, where he first taught and then was dean of the law school. And then in 1978, Judge Pollack was appointed to his current position as the United States District Judge for the Eastern District of Pennsylvania, and he continues to teach as an adjunct member of the Penn faculty. From 1950 until 1978, when he became a judge, Judge Pollack was associated first as a volunteer lawyer and then as a board member and vice president of the NAACP Legal Defense Fund. From 1950 to 1955, he worked with Thurgood Marshall in working on the cases leading up to Brown, and thereafter he played a continuing role in NAACP litigation, working to defend freedom riders and to challenge Florida's anti-miscegenation law. And service that continued until he went on to the bench. We can say formally that he went on to the bench. Next to her, we have Kathleen Cleaver, who's spent her life in various roles of human rights advocacy. She started college, didn't quite go to law school immediately, leaving college to take up a role in the struggle against racism in the United States. She served from 1967 to 1972 as Communications Secretary of the Black Panther Party and was the first female member of its Central Committee. And she served in that capacity as a spokesperson for the party, speaking across the country and also working to organize the defense of Huey Newton. Thereafter, she was outside the United States living in exile with her former partner, Richard Cleaver, and returned to the United States in 1975, and somewhere in the 1980s, and I don't know the exact sequence of events, she entered into Zoom life, returning to school at Yale College, and then began as a student at the Yale Law School. She graduated in 1989. But during the time that she was here, she worked a stint as a summer associate, and thereafter, I'm told, at Cravat. In that capacity, she worked on some testimony for Judge Port's nomination to the Supreme Court for the Lawyers Committee for Civil Rights, and actually this was work that made its way to Nick Katzenbach, who was reviewing this testimony, so there's a little exchange earlier about this. She served on various anti-bias commissions and taught and lectured across the United States at various campuses. Emory, Sarah Lawrence, Cardozo Law School, and presently she's a senior lecturer in the African American Studies Department at Yale, and she's a research scholar at the law school. The last member of the panel, Jeff Berman, graduated from the law school in 1996. I first encountered him as a student, shortly after I got on the faculty here, and he is went out to start his life after the law school as a staff attorney at the Public Defender's Office for the District of Columbia, where he specialized in the representation of children who were charged in adult criminal courts. But then moved on to work on the Hill, and he's presently Chief Counsel to United States Senator Chuck Schumer and Minority Staff Director of the Senate Judiciary Subcommittee on Administrative Oversight and the Courts. He's also serving as an adjunct professor at the Georgetown University Law Center. When I was speaking about his qualifications, I thought among them was the fact that he was not yet born during the time that most of the other panelists were fighting on civil rights issues. So he stands here as the link in the piece of history between past and present, and is going to help us reflect some on the relationship of Congress and the court in matters of civil rights today from his position on the Hill. And with that, I'll start the panel, and we've decided that Judge
classmate Oliver Hill from the Howard Law School. We're looking at Spotswood Robinson from the Howard Law School. We're looking at Robert Carter from the Howard Law School. And all of them under the aegis, initially, of an extraordinary figure, Charles Houston, and his successor as Dean, William Hastie. That is the essential legal heritage that, from which everything that we're celebrating this weekend stems. And this is not to say that there weren't some of us from outlying institutions, young people recruited as assistants, and that was an extraordinary opportunity that we had. But we were there under the leadership of Thurgood Marshall. To be sure, there were others as weighty, but who were they? They were James Nagrett, distinguished professor of constitutional law at the Howard Law School, who was soon to be dean and then president of that university. When I'm not going to talk at any length about that initial phase, because I want to get on to what happened after Brown, but I don't want to leave that image of the working group on Brown without bringing to your attention a couple of anecdotes that are characteristic. When this morning Professor Klarman was talking about Justice Jackson and his view that weren't these matters that should be dealt with not by the court, but politically by Congress, and Justice Reed, in a different accent, echoed the same thing, and there were feelings among the judges that sure, wouldn't it be nice if somebody else took all of this over? It wasn't really for the judiciary at all. I found myself thinking back to the reports of Thurgood Marshall in the mock argument at the Howard Law School in advance of the real arguments before the court. Mr. Marshall being asked by someone on the tribunal, the mock tribunal, well, Mr. Marshall, does this court have power to grant the relief that you're asking? Is this a matter for a court of law? Where do we get the power to do this? To which Mr. Marshall's answer was, in effect, as follows.
White boss, you got the power to do anything you want to do.
That, I think, ties in with what Professor McKenna had to say about hierarchy and subordination. I don't mean to suggest that there was no room for those of us who were very junior. It's hard to believe that some of us were very junior at the time, to do anything more than take notes. There were important contributions made. There were sufferings for us. I think Jack Weinstein will agree. Bill Coleman, Charles Black, Jack Greenberg, of course, Tommy Motley. We did a little work, and occasionally, I guess it was helpful. Though I have to make a confession, which I hope won't go beyond this audience. When I was working in the State Department in the summer of '53 and was receiving drafts of the brief that was to be filed, and one came in from New York with a request by Mr. Marshall for an immediate return of any comments at all, and I read quickly through the draft brief and found what I thought was a flaw and what I thought was a central part of any brief, the summary of arguments, since I think that's where judges look to see what really is being pushed. And I found the summary of argument kind of weak, and so it was up to me to get out my yellow pad and redraft the summary of argument and send it back to Mr. Marshall. And that I did in the next 30 minutes. I really worked swiftly and efficiently and productively. I can't praise myself enough. And I brought the yellow pad to the young woman who was secretary to me and about 6 other State Department lawyers. This was a point I may add in my State Department career where I had literally nothing to do. I handed this to her and asked her if she would be kind enough to type it. I did not identify just what aspect of the foreign relations of the United States which I was appertained to. And I came back in 11 minutes, and she hadn't quite finished typing it in 18 minutes, but she was nearly through. Finally, in 23 minutes, she had finished it, and I took up the typescript and was very excited to read through it. And she said to me how much she had enjoyed working on this piece of paper, and it was terribly interesting and so well written. She said, pleased by this first review. And she did have just one question, just one small question. Would I entertain the question, of course, whatever. She said, I wasn't entirely sure when I finished reading it and rereading. There was just one thing I didn't understand. Ms. Pollock, is it that you want those little colored children to go to school with the little white children or not to go to school? Fortunately, that draft did not survive. What came after Brown, immediately, of course, was that the Legal Defense Fund and, in parallel, the NAACP, of which Bob Porter shortly became General Counsel, those two organizations, which essentially had a monopoly for many years on the ongoing civil rights litigation, they worked on implementation of Brown and seeking to desegregate schools. And they were the working forces that group of continuing lawyers, Mr. Marshall himself, until 1961, he became a judge of the Second Circuit, and then Jack Greenberg and Connie Motley, continuing at the Legal Defense Fund, Bob Porter at the NAACP. If you look up the Supreme Court records of those 3 extraordinary advocates, they were matched only by Marshall's record of extraordinary success. And they carried forward effective implementation in the school areas, and the NAACP itself carried on important litigation to protect the integrity of the NAACP being threatened by the political leadership, most especially in Virginia and Alabama, and in Virginia protected the legal enterprise. I'm now talking about the victories at first in NAACP versus Alabama and then NAACP versus Button. These were extraordinarily important victories, and the Button case really helped establish lawyering as a form of protected political activity, fundamentally important constitutional work. And of course, the work that Bob Carter did for the NAACP was followed up when Nate Jones became General Counsel of the NAACP with equal vigor and effectiveness. What deserves mention is that the allocation of the resources of this small group of lawyers was terribly important. One could not waste one's time on secondary or tertiary matters, either in the first wave of enforcing the Constitution or in the second wave of pursuing that, but also working out the basic meaning of the civil rights legislation, starting with the '64 Act, which we'll hear more about because it's in Nick Katzenbach's domain. But it's important to remember that much of the judicial architecture under the '64 Act came about through, again, the continuing litigation of these groups of lawyers to a greater extent, to a substantially greater extent than government litigation by the EEOC or otherwise. In the early 1960s, Jack Greenberg asked Bill Coleman and me to meet with him to ask about whether we thought the Legal Defense Fund should undertake a representation which was entirely divergent from the implementing legislative litigation that I've been talking about. The Legal Defense Fund had been asked by lawyers in Florida, the lawyers representing the two defendants in Florida versus McLaughlin, whether the Legal Defense Fund would take over their appeal to the United States Supreme Court. What was McLaughlin about? That was a prosecution of a black man and a white woman for violating the Florida statute which, and my paraphrase is virtually verbatim, committed the crime of being persons of different genders and different races, quotes, occupying the same room at nighttime, close quote. That was the crime. You may think that that was quite closely related to Florida's anti-miscegenation statutes. It was. But the couple did not represent themselves as being formally married. They were and all of us would call a common law couple. They were a household and they were criminally prosecuted. Jack Greenberg wasn't sure that we ought to take this case. He said, you know, this anti-miscegenation problem is not one really of vital on our agenda. Certainly didn't really regard it as a major matter compared with the real issues of school segregation and related matters of mass racial discrimination. People who want to get married, and they arrange their lives so as not to run into trouble with the peculiar states that have these laws. This case becomes the challenge, effectively, two statutes at this time. We can take it on, but, said Jack Coleman and me, we, the Legal Defense Fund, we essentially have a charge account with the court. And every case we take there draws on that charge account. Maybe this isn't something we ought to be asking the court to do as against the other things that have priority. What do you think? At that point, as I was an academic and full of all rights and bright ideas, I said, Jack, there's an easy solution to that. Notionally, this is an appeal under the then jurisdictional statutes. It's an appeal of the state statute that's called into question. But we don't have to call it an appeal. We can call it a cert petition. And then if the court wants to take the issue on, we can grant it. If the court doesn't want to take the issue on, it'll deny it. And so it's up to the court to decide whether to put this down against our account. At which point Jack Greenberg looked at me rather fixedly and said, listen here, Polly. If we take this case, we are the lawyers for the defendants, and we have no business doing anything less than the very best we can for them. We can't call it a cert petition if we have a right of appeal. Yes, no, yeah, and that was, we didn't have any required course of legal ethics when I was in we took that case, and the court unanimously overturned those convictions, and that, at least Coleman and I believe, that made the Loving case, the formal one, knocked out anti-miscegenation laws a couple of years later, a slam dunk. There wasn't a legal defense fund case. But I remind you of that illustration because it suggests to you what the institutional enterprise and institutional strategies were of the lawyers who carried on for many, many years the important responsibility of undertaking the first phases of implementation of Brown.